The buyer attachment cover page must be delivered to the buyer before any offer is submitted. It is not part of the residential resale real estate purchase contract terms. It is a consumer advisory and risk management document. In the metropolitan Phoenix market, Gilbert, Chandler, Mesa, Scottsdale, Peoria, Queen Creek, offers move fast. However, speed never replaces statutory compliance. Delivering this document protects the buyer, the agent, the designated broker, and the brokerage under ARS, paragraph 32-2153, grounds for discipline, and AAC R428-1101, professional conduct. Failure to properly educate a buyer before contract submission can create exposure for negligent misrepresentation or failure to exercise reasonable care. This page sets expectations and reinforces that buyers, not brokers, carry investigation responsibilities. It also aligns with broker supervision requirements under AAC R428-1103, which requires brokers to establish systems to ensure contract compliance and consumer protection. The buyer attachment is where professional contract writing truly begins. You are entering into a legally binding agreement. Arizona contracts are enforceable under ARS. Paragraph 44101, Statute of Frauds. Once signed and accepted, the contract becomes binding. Courts consistently enforce properly executed real estate contracts. In Hill v. Jones, 1986, the Arizona Court of Appeals reinforced the importance of material disclosures and the enforceability of contract obligations once parties are bound. Phoenix Metro example. A buyer in Scottsdale submits an offer on a luxury home near DC Ranch. The offer is accepted. 2 days later, the buyer wants to withdraw because we changed our mind. Without a valid contractual contingency, cancellation may expose the buyer to loss of earnest money or damages. The buyer attachment exists to prevent this misunderstanding before it happens. Read the entire contract before signing. This instruction directly supports professional conduct under AAC R428-1101A, requiring licensees to protect and promote the interests of the client while dealing fairly with all parties. Encouraging review reduces claims that the agent did not explain the contract. Gilbert example. A first-time buyer initials a contract, but later claims they did not understand the appraisal contingency. Delivery of the buyer attachment demonstrates that the brokerage urged a full review prior to signing. Review the Residential Seller's Property Disclosure Statement, SPDS. See Section 4A. The SPDS is seller-provided information. Under AAC R428-1101E, agents must disclose known material facts, but are not inspectors. The buyer attachment shifts investigative responsibility to the buyer. Mesa example. The SPDS indicates prior roof repairs. The buyer ignores the disclosure and waives inspection. After closing, a leak occurs. The buyer attachment warned the buyer to investigate unclear answers or blanks. Review the inspection paragraph. See Section 6A. Inspection rights are one of the most powerful protections in the Arizona contract. Buyers are encouraged to hire qualified inspectors, including general home inspector, HVAC inspector, mold inspector, pest inspector, pool inspector, roof inspector. This aligns with Arizona case law emphasizing buyer due diligence and supports the principle reinforced in Lombardo v. Albu, 2001, regarding reliance and investigation duties. Chandler example. A buyer waives termite inspection to strengthen an offer in a competitive market. Months later, structural damage is discovered. The buyer attachment clearly advised hiring qualified inspectors. Verify square footage. See Section 6B. Square footage discrepancies are common sources of litigation. Under AAC R428-502, advertising requirements, brokers must avoid misrepresentation. Encouraging independent verification protects the brokerage. Peoria. Example MLS shows 2,400 square feet. County records show 2,150. Buyer fails to verify. After closing, a dispute arises. Proper delivery of this advisory demonstrates that the buyer was urged to confirm. Verify sewer or septic. See Section 6F. In areas like Queen Creek or the outskirts of Mesa, septic systems are common. Septic inspections carry different risks and maintenance requirements. Encouraging verification reduces post-closing liability claims. Confirm insurability. See Sections 6A and 6E. Insurance challenges have increased in Arizona due to wildfire risk and aging roofs. Buyers must confirm insurability during the inspection period. North Scottsdale example. Buyer enters the contract near the desert preserve. Insurance carrier declines coverage due to brush exposure. Without early confirmation, closing is delayed. The buyer attachment warns buyers to verify insurability immediately. Apply for your loan now. See Section 2F. Financing timelines are strict. Under ARS, paragraph 32, 2153, failure to perform contractual obligations can create legal and disciplinary consequences. The buyer, not the broker, is responsible for delivering funds to escrow on time. Tempe example, buyer delays providing income documents. Loan status update reveals underwriting delay. Seller issues cure notice. Buyer risks contract cancellation. The buyer attachment warned of timeline responsibility. Read title commitment and CC&Rs. See Section 3C. Buyers have 5 days to review the title commitment and governing documents. In HOA communities throughout Gilbert and Chandler, CC&R restrictions impact rental ability, solar installation, parking rules, and architectural changes. Gilbert example buyer purchases in Power Ranch, intending to operate a short-term rental. CC&Rs prohibit it. The buyer attachment instructed review within 5 days. Conduct a thorough pre-closing walkthrough. See Section 6L. The walkthrough confirms the property condition prior to recording. After closing, leverage diminishes significantly. Glendale example. The seller agreed to repair the HVAC. Buyer skips the walkthrough. After recording, HVAC fails. Buyer loses negotiation leverage. Buyer's advisory reference. The buyer attachment directs buyers to the Arizona Association of Realtors, R, Buyer Advisory. This reinforces independent investigation and expert consultation. Encouraging legal consultation aligns with protection duties under AAC R4 281101 and reduces unauthorized practice of law concerns. Wire fraud warning. Wire fraud is a growing threat in Arizona. The warning reinforces cybersecurity diligence. Brokers should implement written policies under AAC R4 281103 requiring independent verification of wiring instructions. Scottsdale example, cybercriminal intercepts email and sends fake wiring instructions. Buyer verifies by phone and prevents loss. The advisory language saved the transaction. How to implement this in your Metro Phoenix firm. Deliver buyer attachment at buyer consultation before writing offers. Have the buyer acknowledge receipt in writing. Store acknowledgement in transaction file per ARS. Paragraph 32, 2151.01, Record retention requirements. Incorporate explanation into buyer presentation slides. Train agents monthly on delivery compliance. Professional systems reduce disciplinary exposure and elevate client confidence. Why is the buyer attachment not technically part of the contract terms, yet still one of the most important documents delivered before offer submission? Answer: because it functions as a consumer advisory and risk allocation tool. It educates the buyer, shifts investigative responsibility appropriately, supports broker supervision compliance under AAC R4 281103, and protects against claims of non-disclosure or failure to advise. If a buyer refuses to read CC&Rs within the 5-day review period and later complains about rental restrictions, what position is the brokerage in? Answer: the brokerage is protected if the buyer attachment was delivered and documented. The buyer was clearly advised to review governing documents within 5 days under Section 3C. How does the wire fraud warning protect both buyer and broker? Answer: it establishes clear cautionary guidance, reduces negligence claims, and demonstrates that the brokerage exercised reasonable care under AAC R4 281101 and supervision obligations under R4 281103.